Um, Welcome everyone to the TiE Camp collaboration session on being dispute-wise through mediation. Our speakers today are Ms. Gayatri B. Kalia and Ms. Rukmani Menon. Ms. Kalia is a former civil servant, a mentor to social startups, and advisor on livelihoods, disability, and skill development. She has seen many firsts which are of big public impact, such as the design of the first direct benefits transfer program and that of DDUGKY, the largest inclusive skill development program. She is an internationally certified and practicing mediator and the executive director of CAMP. Welcome, Ms. Gayatri.
Thank you, Surya.
Ms. Rukmani Menon is a practicing lawyer with over 27 years of experience in the Supreme Court of India, High Court of Karnataka, and the tax tribunals. She is a certified mediator from the Bangalore Mediation Center, JAMS, Singapore International Mediation Center, and is on the Global Mediator panel of UNDP. Ms. Rukmani Menon is also a director and mediator at CAMP. She has mediated over 500 cases and has expertise in commercial tax and post matters. Welcome, Ms. Rukmani.
Thank you, Surya.
So let's begin the session. Anubhav, if you can share the PPT. No, I hand it over to Ms. Gayatri.
Yeah, thank you, Surya. I will have asked for the PPT very shortly. But first, let me say what a privilege it is to be with all of you, brave hearts. Peter Drucker once said that behind every enterprise, successful or otherwise, are men and women of great courage. And how true it is. We know this in CAMP as a startup ourselves, the pains and tribulations and the spine as well as the grit it takes to be an entrepreneur. So it's a great privilege to be amongst all of you today. I would want to sort of put up a picture for you, and I'll ask my colleague here, Anubhav, to put it up. Anubhav, can you go to the second slide? Next one. And tell me what it is that this picture evokes in you. Yeah, you can put it on the chat box. Yeah, I see stress. I see anxiety. I see some of you saying extreme nervousness. Yes, all of that. And I'm sure that you are no stranger to these emotions as an entrepreneur, because along with passion and along with this desire to make a difference also comes great anxiety and stress in setting up a startup and converting it to something which is sustainable. But in the aspect of stress, there is a principle that becomes your buddy, your mentor, or your guide. And that principle is what is called the 90-10 principle. Can we go to the next one? Yeah. Yes, some of you are writing saying Stephen Covey's. Yes, the smart Stephen Covey principle, which says that 10% is what happens to us, but 90% we have control and agency in converting what happens to us in what it really means to us in our lives and how it can impact our lives by how we react to it. And this 90%, part of this 90% is mediation. Can we go to the next? So the power of 90 that you can exercise it through mediation as well by ensuring that your stress, your anxiety, your nervousness does not become the root cause of conflict. And beyond that, if there are issues of conflict, which are inevitable in life as in startups, that you do have this tool which puts the power of 90 in your hands. Can we go to the next? We'll see how that is made possible by mediation by a couple of cases that we in CAMP have done and can then share with you about how mediation helps you to take control of disputes and conflicts that could paralyze what you're achieving to do. So there's this case where there were two friends and they decided that they wanted to make a difference and decided to set up an IT company. A few years passed by, and when a lot of work and continuous work and stress and anxiety of building a company happens, one tends to not communicate. One tends to have assumptions convert itself into differences, which are simmering and latent. And that's what happened here. So after a period of intense pulse going to 120, sleepless nights and, family getting stressed out, one of the partners decided that it would be impossible for him to work with his other partner anymore, and decided actually to sell his stake, sold his stake, and got out of the business. And A was actually the person who had the domain knowledge for the business. So it did impact the future of business in which both parties had invested heavily, significantly. But having sold out, A was not out of his resentment, his bitterness, his feeling that at the end of all that investment, he had to walk away from what he considered his baby, and therefore decided to file a suit. But one of the angel investors came in and said, why don't you try mediation? And when mediation came in, what it did was allow channels of communication to get opened between the two and allow each of them to see where the other came from. It allowed for restructuring each roles and responsibilities and perspectives, and allowed for the IP to be shared, which previously did not get shared, and for co-investments to continue, even if it was as separate entities. So this is one case where mediation did the magic of ensuring that investments did not go waste because of a conflict which was rooted in inevitable stress and challenges that come with that stress. Can we go to the next slide? This is another case, a case that I dealt with personally, of a firm which specialized in IPR and another firm which was a general law firm. The IPR firm's spouse was a partner in the general law firm, and both of them had decided to collaborate. One fine day, the IPR firm decided that they were not getting value for their collaborative partnership and said that, let us get out of this partnership. But her underlying interest and intent was to work together because she felt that there was so much of work that the IPR firm brought in for general law, and it didn't make sense to go out of the family circle, as it were. The general law firm had the underlying interest was that the spouse was investing too much time in the IPR firm, was not giving enough time in his own practice firm. And these underlying causes was coming in the way of their functioning effectively. To add to that was the fact that there was not well-structured roles and responsibilities, service level agreements, or deliverables, or even a systematic review process. Because as it happens when you have friends or relations or spouses, one tends to go with the flow. But that informality at some point of time becomes a great bottleneck. So mediation came in. It allowed both the parties to see the immense benefit and potential advantages. It allowed them to restructure the relationship and value of communication. It put the non-spouse partner at the forefront of that relationship management, which was a big step forward that they set for them. And both parties continue in the business. And the last I heard from them is it's far more effective and far more flourishing. Well, let's go to the next. So when we look at startups, you know that 65% of them flounder due to startup founder conflicts. And many of them feel that they have differences in the way in which they see the future of the businesses, or there is a deep-seated feeling which is unexpressed that one is giving more than the other, but the investment or the returns are equally shared. There's also, of course, the investor-investee conflicts which come in, and strategic vendor conflicts which are critical to the survival and the growth of the company. And all of this does not need to look at litigation or to look at simmering discontentment an impotency, which feels that there is no way out but to suffer and struggle. The way out and the tool that you have is the power of 90 through mediation. Can we go to the next? So what is mediation? I would ask my colleague and friend Rukmini to come in and take us through the next few slides on mediation and the magic that mediation can do for you.
Thank you, Gayatri. So, thank you for having me here. You have had Gayatri talking about how in 2 cases she talked to you about breakdown of communication and what they went through, and the anguish it caused the parties, the waste of time when they went in for litigation. This is true of not only startups, but any business suffers a lot in the time they spend in litigation or arbitration. Having said that, I would like to say one thing, that, you know, there are cases which are fit only for litigation. It's not that all cases can come in for mediation. So lawyers should advise their clients as to what you can come in for mediation, what sort of cases. And once you get in for mediation, it saves a lot of time for the parties, and it's a big boon for the businesses. So with that, I'd like to talk to you a little bit about what exactly is mediation. So mediation, when does a dispute happen? A dispute happens when, as Gayatri pointed out, communication totally breaks down between parties and misunderstandings crop in. And then a conflict comes in, and they start egos start, you know, the egos come up. So mediation is nothing but a facilitated negotiation. A facilitated negotiation in which a third party neutral does not decide for the parties like in a litigation or an arbitration, but a third party neutral helps the parties in negotiating terms and conditions to reach a settlement. So the outcome in a mediation is in the hands of the parties, and it is a process which is voluntary, which is the parties have to come in of their own volition. And once they decide on these terms and conditions, they are binding on both the parties. Since it is not a direction given by a third party, but it is something which they have arrived at on their own. So either the settlement which they arrive at is a binding contract between the two, or it could be converted into a conciliator's award, which is enforceable under the Arbitration and Conciliation Act. I had talked to you about some of the aspects of mediation: neutrality of the mediator, voluntary, outcome being in the hands of the parties. One more very important aspect is that mediation is a very confidential process. What happens in mediation stays within the parties, the lawyers, and the mediator. Nothing can be revealed either by the mediator or by the parties, either in court or elsewhere. So this is what gives parties a lot of confidence to speak freely, helps the mediating and developing trust and creating a comfortable environment for the parties where they're able to talk freely. And mediation is, since it is, the outcome is in the hands of the parties, it is a win-win situation for both the parties. You're all aware that in a court or an arbitration, it's one part, an award or an outcome of court would be in favor of one party, and the other loser can go up in appeal. I mean, the person who loses or has an unfavorable decision. And the other one more advantage of mediation is that, I've said it, I'd like to emphasize it on this aspect again, that having reached an agreement, it is final and binding, unlike a court order which can be appealed against. Now, this helps saving time and costs, which I will come to in the next slide. Next slide, please, Anubha. Now, this is a slide. What exactly do you observe over here? So I can see some of the answers. Some of them are saying rabbit, some of them are saying a bird, a duck. So, it's perspectives. It's very important in any dispute for parties to understand each other's perspectives. And that is what is the most important thing in mediation, that the mediator, the neutral, helps the parties in understanding each other's perspectives. Nobody is wrong and nobody is right. So here it cannot be said that whoever said it's a duck, the other person is wrong, or whoever said it's a rabbit, the other, the rest of the answers are not correct. So understanding perspectives is extremely important in mediation. Next slide, please, Anubha. So having briefly explained about the process of mediation, it is very clear that as Gayatri was talking about her cases, the two disputes. So the parties, having understood what is the underlying interest, from understanding each other's perspective, you move from position to interest. When you say that, it means giving up on your respective egos or trying to prove the other person wrong. As I said in the beginning, it's the breakdown of communication which leads to conflicts. Mediation is this bridge which rebuilds communication between the parties, which is extremely important in resolving any dispute. And it shifts focus from this blame game which goes on. You did this to me, you did that to me. So look forward. But having said that, I'd like to say one thing. There are certain pain points. It's very important for the parties to understand the pain points of parties, for which the mediators do a little bit of digging work. But having done that, it is important for mediators to ensure that the parties move away from the blame game and move on to understanding and communicating so that they can go towards a resolution. And as already explained, the resolution on what terms are the parties going to resolve is not in the hands of a third party, either a judge or an arbitrator. The outcome is in the hands of the parties. They are the ones who decide, out of the box solutions to resolve their dispute. Next slide, please. This is a comparison between the most commonly used modes of dispute resolution: litigation, arbitration, mediation. And litigation, as all of you are aware, is the judge decides. So you file a case in court against A, files against B, and you follow all the processes, which are set forth under this, if it's a civil case, under the CPC, and follow the evidence law, etc. Arbitration is under the Arbitration Act. Mediation is something where, as already explained to you, a neutral third party facilitates the resolution of a dispute and helps the parties to negotiate. There are certain important aspects. Now, if you see most of them, party autonomy in litigation, it is not there at all. Arbitration, party autonomy is there to the extent that the parties are able to choose the arbitrator. That's about it all. After that, when it comes to the entire process, it is their respective counsels who appear before the arbitrator and argue out the case of their respective clients. At the most, there is examination and cross-examination of the parties. In mediation, it is the parties who decide the outcome. Flexibility. In litigation, there is very little flexibility. There is a set process one has to follow. The process has to be. In arbitration also, the rules of arbitration have to be followed. In mediation, we always design a mediation as per the requirements of the parties. I'd like to give you a small example in this. Like usually in mediation, we start with a joint session with all the parties present, with the lawyers present. But I have done a couple of mediations where the parties request that, we rather, even on screen, we rather not face each other. We want to go straight away into private sessions, which are called private caucuses. So it is the need of the parties which helps us design the mediation process according to these requirements. So it's an extremely flexible process. Having said that, it is important to understand that mediation is always done under the shadow of law. You cannot go beyond what is permitted in law. Role of a third party in litigation, litigation and arbitration, it is the arbitrator and the judge who decide the outcome. And in mediation, the mediator plays a facilitative role, as already explained. The mediator is just there to help the parties negotiate terms and conditions. Confidentiality and privacy. In litigation, all court battles are sort of fought in courts. You cannot have any privacy to talk about. So there is no confidentiality per se. In arbitration, it is a closed process where only the arbitrator and the respective parties are there. In mediation, it is everything is private, everything is confidential. Nothing needs to be revealed to anybody else but for the parties, their counsels. You need not even talk about you cannot talk about the terms of settlement, the mediator or the parties. Even if there's a similar dispute, it cannot be given as an example, unlike a court decision. Time saving. We had done an analysis. I had done an analysis with the help of a colleague where I'll take both these together, time and cost saving. A litigation in any civil case of debt recovery could take about, very easily about 10 to 12 years. Arbitration, the more complex cases, though 18 months has been prescribed under the Act. But there is an appeal provision, and that it could go up to 3 years. In mediation, we at CAMP, we have when it used to be physical sessions, we used to do maximum a day of mediation, which used to be from 10 to maybe 10 at night, or followed up a little bit the next day. Not more than 14 to 15 hours. But since we started doing online mediations, maybe it become 3 hours because you cannot do continuous online sessions. Maximum 3 months, or some of the parties need a break. So nothing more than 4 to 5 months. Now, what has to be understood is that when so much time you're spending in court or in arbitration, the cost goes up that much. Whereas in mediation, since it is being resolved so fast, the cost comes down automatically. Moreover, arbitration is an extremely expensive process. Not that litigation is not. Our arbitrators are mostly retired judges of the High Court and the Supreme Court, and the fees per day are extremely high. Mediation costs are barely about 1/10 of the costs of litigation and arbitration. Ease of process. In litigation, it's very process bound. As I explained, evidence, rules of evidence, this civil procedure code. Each case, whenever we do a filing, then there are so many mistakes pointed out at the registry that this form is not there, that is not there. in the affidavit, the signature of the party is not okay. Arbitration is that way comparatively better. In mediation, we have, it's made, the mediation is a process which is made easy for the benefit of the parties. You have very brief mediation, very, very crisp mediation briefs, few documents. So it really sort of is a big comfort for the parties. And what's the last one, Anubhav? I'm not able to...
Enforceability.
Enforceability. Okay, I'm sorry. I couldn't make out. Enforceability. Now, litigation, of course, all court decrees are enforceable, but even if we have a decree in hand, for example, I'll just give you an example. I win a recovery case, I've got a court decree. Does that mean that if A gets a decree against B, that he can go with the decree to B and say, hey, give me this money? It doesn't happen that way. You have to go in for execution, which execution proceedings take another couple of years. And, by that time, if the other party has become totally bankrupt or something, that's the end of it. You're left with a paper deal. Arbitration, you can enforce it under the Arbitration Act, but that takes time again. Mediation is enforceable either as a, as a contract between two parties. And since in this issue of enforceability in mediation, we have never faced at camp. We have had a 85% success in mediations at camp, 85 to 90%, and whatever the 90% cases we have resolved, not one case has this question of enforceability come up. The other way of enforcing is a mediation settlement is converted to a conciliation award under the Arbitration and Conciliation Act to get the sanction of court. There again, we've had a couple of cases where it has got converted to a conciliator's award. But I mean, the question of enforcing that, they've just got the sanction of court and the parties are happy with it. But the question of enforcing, even in court, when it's a court-referred mediation, this problem does not come up at all. In court, even just about 1% of cases in the court annex mediations have been reopened for some reason or the other. Next slide.
Can I just come in here for a minute?
Yeah, sure.
I just want to emphasize saying that we cannot overemphasize the principle or the philosophy of mediation. Let's stay in the previous slide on the comparative slide, Anubhav. Go to the comparative slide.
Comparative, yeah.
We cannot overemphasize the principle or philosophy of mediation, which puts the parties at conflict at the center. It's like what Jeff Bezos says, that we don't worry about our competition, we're obsessed with our customers. Mediation is obsessed with comfort and ease for parties in conflict. The whole philosophy is that parties in conflict are already stressed. Therefore, the process of dispute resolution should not add to their stress.
Exactly.
And this is a very important element of mediation that I want for you all to understand.
Yes, it is not only cost, very good point by Gayatri, it is not only cost saving and time saving. It helps sustain relationships. It saves a lot of stress. Courts, litigation and arbitration are very stressful. Mediation is extreme, saves the stress. Thank you, Gayatri, for that.
Yeah, I just want to add one more, Rukmini, before you move on. The other important thing is to understand what party autonomy can mean for you if a conflict comes up. For example, if a judge or arbitrator were to give you a court order or just give you a judgment, even the person who wins most often than not is not fully happy. And there is a winner, there is a loser. There is very little space for parties to craft a solution which allows both of you to win and move forward in your relationship. For example, Rukmini herself had shared a particular case where there was a payment recovery process for goods that were not received properly or not utilized or damaged or so on. And the mediation helped by her helped them design a process of recovery and kind of an installment payment unheard of in the history of commercial litigation, where a court order would have simply said pay today or else. And what it would have happened is the enforcement would have become impossible or the party would have disappeared. Whereas here, both the parties allowed themselves to craft a solution which was in its design itself is very innovative. We are not sharing that from a confidentiality perspective, but it allowed for the parties to actually receive the money, which otherwise would just not have happened in 12 to 20 years.
Exactly. So, that's what I meant when I said that even if you get a favorable order in a litigation, when you go in for execution, it takes the same amount. You know, it takes a considerable amount of time, and the other party from you whom you have to recover may be bankrupt. So it would be so much better in a process like mediation, where you resolve it on, as Gayatri again pointed out, in a case of mine where, you know, they fully realized that they're not going to get anything from court by getting a favorable order. At the end of the day, that other guy the person who owed them money would just disappear. So a very good settlement was reached. I mean, they themselves crafted out with my help as in my facilitative role, you know, terms and conditions which help them rebuild the relationship, which is very nice to see.
Yeah.
At the end of the day,
there's agency that the mediation provides in the hands of parties who think they're in a conflict and cannot see a way out. But in every single case that we have seen, they've crafted a way out that has worked best for them. Yeah, please.
Yeah, move on. Yeah. Gayatri, you're taking this, or should I take it?
Yeah, take it. I'll take it on. So when we were talking about how much savings, cost, and time that mediation provides as in terms of a dispute resolution situation, this is a survey that is done by Singapore Institute for Development of, in terms of mediation and ADR tools. And they compared litigation, which you can see is actually the last bar, and the middle bar is mediation, and the first bar is arbitration. This is a survey which was conducted amongst over 300 respondents of 40 countries, half of them general counsels or lawyers, and half of them business heads. And you will see this was conducted, by the way, just a year after the Singapore Convention was notified on mediation in 2019. And this pertains to people's inputs on how mediation helps in cross-border or international disputes. And for a kid which was just about 1 year old, you will see that mediation is giving a run for money for the other tools. So you have them in enforceability 55%, with 65% litigation, and 56% litigation, 65% arbitration. And that is because the processes of enforceability across borders is just evolving, but still 55% and 56% with reference to arbitration. Then you see neutrality, mediation tops at 72%. If you see finality, because of the enforceability issues, the finality is at 55%. But the study, if you were to read it deeply, it will also say that people who choose mediation are really not bothered about enforceability. As Rukmini said, less than 1% globally show that mediation settlement agreements have to go for enforceability at all. Then we have speed at 68%, much, much higher than either litigation or arbitration, and costs at 65%, which is 65% of savings as compared to the rest of them. So, and we'll see that in the Indian context, the case, the study that Rukmini referred to. Let's go to the next one. So in the Indian context, when in typical debt recovery cases, you see that the time saving is as much as about 95%, and the cost saving is around 98%. So, and that pans out in almost every case we see. We just had a case of a land tenancy dispute where people had gone for arbitration, which took more than 3 years to about 8 years. Litigation costed about 10 to 12 crores. Arbitration costed about 2 to 3 crores, no resolution. Came to mediation, resolved within 3 months at 3 lakh of rupees. So that is the power of mediation across spectrums and across cases, except criminal cases and certain cases which are considered to be non-mediatable. Let's go to the next. So we'll take a small break for questions and answers. And I was noting that in the chat box that some questions were coming up. Stay at the question and answer, Anubhav. And Surya, do you want to just put out the questions to us?
So, ma'am, we have a few questions in the chat box. I'll put them across to you. So the first question says, how can we bring a reluctant party in for a mediation?
Okay, Rukmini, do you want to take that question first?
Yeah, sure. It's as I had explained in the beginning, mediation is a voluntary process, and you cannot summon, unlike in court and arbitration, a party to come in for the for a mediation process. So at camp, we have capable case managers, you know, who a party, how it typically works is a party comes in for mediation, and then at camp, we reach out to the other party and we explain to the other side, what is this mediation about? How will it work for the party? What are the advantages of it? You know, how would it compare to either arbitration or litigation? And what we generally do is tell them to come in for a 2-hour session to try out this process of mediation, so that they get a taste of mediation. And we have seen this happening practically, that there are some parties, you know, now at least at this moment of time in 2022, there is much more awareness about the process of mediation in the corporate as well as the legal circles. Now, about even 2019-20, it was not so. You suggested mediation, people said, yeah, we have negotiated, so we have not been able to resolve it. So where's the question of coming in for another negotiation? So it has to be explained to them. So when they come in, the other side comes in, you can see the slight reluctance of the parties. But once they sit down with the third party neutral and get a taste of how the process is going to work, it becomes very easy for them to, not easy for the mediator to persuade them, but easy for them to continue on once the mediator has, you know, made them develop a kind of trust in the process, made them comfortable in the process. So it is this initial session of building up their confidence in the process is extremely important. I would like to draw a slight, comparison with the court process over here. In court process, cases are referred to, because I happen to mediate in the court process also. The judges tell the parties, okay, why don't you try mediation? They're directed to mediation. But as mediators sitting there, we cannot force them, no, you sit here and do mediation. But there again, the same, logic applies. When they hear about the process, when they understand about the process, they are very, very happy to continue. And another aspect which, we have found useful is to reach out to the councils and have sessions with the councils who in turn coach them, who are in turn are able to give very vital information to the party, to their respective parties. And that is how you get in a reluctant party to the table to come in for mediation. Gayatri, you want to add something? You are on mute.
Yeah, I'm just going to take a related question to this, which is someone who is asked whether, when one of the party reaches out to a mediator, will the other party be more reluctant because they feel that they are your mediator, right? So yes, there could be that kind of a thought initially in people's mind, but organizations like CAMP and mediators like CAMP have a very well-defined process where we do, as a part of the reaching out and orientation information that we give to the parties, tell them and inform them about the neutrality of mediator, the confidentiality of the mediator, and how that would be effected in practice. And most times, most of our cases are where one party is an initiating party, wants to mediate and reaches out to us, and the other party is not even aware of mediation or is not interested. But when, like Rukmini says, a well-trained case manager reaches out and informs them about what mediation is, in 99 out of 100 cases, they choose to adopt mediation. So over to you, Anubha.
Ma'am, there's another question relating to the same topic, which talks about, can we go for a mediation at any time during a dispute?
Yeah, Rukmini?
A very interesting question. Yes, you can go. It's not that once you start legal proceedings in court or before an arbitrator, you cannot opt for mediation. The ideal situation would be that you have a clause for dispute resolution. Most of the contracts previously used to only have negotiation, arbitration, and litigation. If you have a mediation clause after negotiation, it becomes all the more easier for parties to come in for mediation. But that does not matter. If I've done a couple of cases at CAMP where civil disputes, where parties were already in court, they had proceeded with the litigation. This happened more so at the pandemic 2020, say June, when parties realized that they were not going to get anywhere, so they opted for they opted for mediation and came into CAMP. And they found, since it's a voluntary process, they can come in any time. So they opted for mediation, arrived at terms and settlement, and then took these terms back to the court for recording their settlement and closing the case. Similarly, in arbitration, excuse me, in arbitration, the arbitrator can give an opportunity to the parties and say that before the award is drawn up, you have the opportunity to go before a mediator and try to resolve your dispute on your terms and conditions with the help of the neutral mediator. But having said that, we have, in India at least, or at CAMP at least, we are very, very particular that the arbitrator who's arbitrating is not also the mediator. Gayatri, you want to add?
Let's take a last question and then come back again at the end for the Q&A.
Yeah, sure.
So ma'am, another question I have here is, how do you resolve egos between founders of a startup?
Right. Ego is not an issue just with founders, it's a human issue. And one of the greatest skills that a mediator has is to go beyond the face of the conflict into what is human. What are the human needs, desires, fears, anxieties, impetuses that are the root cause of conflict. And therefore, the mediator's skill, you'll have to choose a good mediator. And the mediation process will ensure that the predetermined constructs that we have about conflict and parties are revisited by the parties themselves to be able to arrive at a solution. Rukmini, do you have anything to add?
Just one sentence I'd like to add. No, I mean, why do egos flare up? Because of, the breakdown of communication. And the mediator is helping rebuild this communication and understanding perspectives. And that itself helps the parties, to move forward, leaving their egos behind.
Thank you for these questions. We'll be back again and have time for Q&A. Let's go ahead, Anubhav. Can we go to the next slide, Anubhav?
Yes, ma'am. Just a second.
So while we are waiting for Anubhav, we had a look at the cost and time savings previously, and we would like to now for you to take you through to what the global trends are. See, one of the major milestones for mediation was the Singapore Convention in 2019. This is a UN convention. India is a signatory, and it put in a framework for how cross-border disputes can be settled through mediation. And it gave a great impetus, not just to international mediation, but also to domestic mediation, as we see the catalyzation it has done to the mediation bill that is underway in the parliament as we speak. Then we have, if you look at mediation, the biggest countries that have moved forward right from the 70s is US and 90s is UK, and with a 70 to 85% settlement rate. In fact, in US, most 99% of the civil and commercial cases go to mediation, not just for small cases, but companies like GE have put mediation as the first tool of defense for conflict resolution. And they have what is called an early dispute resolution design mechanism. And we have cases that have been done by Singapore Mediation Center, which are about 5,200 cases worth over 10 billion, and 70% settled with 90% within 1 day, which is also what happens in CAMP, where 90% of our cases, 80% settlement rate and 90% within, most of the time within 1 day or maximum 3 months. Then you have Italy, which adopted mediation, and you can see the time and cost savings and the great impact it has on the productivity of an economy, where it unlocks unproductive capital and litigation for productive investment. And then you have where mediation is used. It is used in interstate crisis, in public or interstate investment issues, in riparian issues, reverse sharing problems. In many cases, in our own country, we tried mediations when the Ayodhya crisis was simmering or raging in the country. Let's go to the next one. And we have here some of the big corporates who are signatory to the mediation pledge, who have said that they will incorporate mediation as a part of their dispute resolution spectrum process and look at mediation first kind of a policy. Let's go to the next one. So we have, I spoke to you about the mediation bill, which is underway in the Rajya Sabha as we speak today. And I would ask Rukmini to come in and give you some of the key highlights which may be of interest to you. Thank you, Rukmini.
Thank you, Gayatri. Till now, we did not have an act, a mediation act. And this bill is a welcome move towards it. In fact, I would like to share a piece of information that as far back as 2016, we have at CAMP, we have worked on the recommendations for legislation and mediation, which was sent to the Ministry of Law and Justice. Now, what some of the main features which we will see in the mediation bill are, it gives more teeth, enforceability under the Act, which is extremely important. Not that it's not enforceable. I explained about enforceability before. Institutional, it gives recognition. The mediation bill, the preamble itself gives recognition to institutional mediation. It is, institutional mediation and court mediation are seen as very important arms which go parallelly together. And mandatory mediation is something extremely important. At the moment, under the Commercial Courts Act, before any commercial case is instituted by a party, they have to go in for mediation until unless they're asking for some kind of interim relief. But the problem here being that there are no sanctions and against a party who refuses to come in for mediation. So this has not seen much success, the Commercial Courts Act. But under the bill, there are certain kind of sanctions, certain penalties for not coming in for two mandatory sessions of mediation, which would which would make a lot of difference. Mediation, as I said, court mediation, court annexed and institutional mediation are seen as being complementary to courts, enhancing dispensation of justice, making accessibility, I should say accessibility to justice, easier resolution of disputes. These are some of the important highlights of the mediation bill, and we are hoping to see it through at the earliest. The next slide, please. So how do you go about adopting mediation? There are a lot of corporates, who ask us, so what does one do? So one is be aware of what is mediation, how does the process work, and how is it going to be of advantage to you? How is it going to enhance your business? And plan for it. When we say plan, point number 2 and 3, plan for it and incorporate it. Plan for mediation beforehand. In this, I mentioned it in one of the earlier slides. Incorporate a mediation clause in your contract. And if a dispute arises, go in for the option of mediation to resolve the dispute initially, to begin with, instead of choosing arbitration or litigation. This helps, as as we discussed, time saving and cost saving for the parties involved. Now, choose your mediator wisely. What we mean by that is that there could be ad hoc mediators, and there are institutions like CAMP. Now, the advantage of choosing institution are many. You have rules set out for, like at CAMP, we have rules which we go by. You have a whole case management system working. You have a lot of technology which goes in together with mediation. And you have a most important being that there's a panel of mediators. It is not one mediator. The parties at CAMP who come to CAMP have a choice of mediators. And so, they're subject matter experts. There are experts, like for example, if a mediation with very complicated financial issues come in, we have the provision for choosing experts for such matters, or for an complicated IP matter. So all these advantages are there for choosing an institutional mediation, and implement it. Implement it in the sense you have a mediation clause which gives you the choice of going to a mediation institution in case the dispute arises. And as and when disputes arise, choose mediation wisely. Choose mediators wisely, which enhances your scope for growth in your business. Can we have the next slide, please? Now, what do you do when you're choosing a mediator? In the previous slide, if you have an institution, there are certain things, you have well-trained, skilled mediators on the panel. You have them trained at credible institutions. Most of us are trained by, either at Singapore or by JAMS. Of course, few of us who are court annex mediators are also trained at the court and ex-mediation centers. And you have subject experts on our panel of mediators. And I have explained this to you. Why an institution? Why is an institution better as compared to an ad hoc mediator? Because the main advantage being you can choose your mediator, you can choose the subject expert, you can choose, you know, a see, it's not enough being trained in mediation. You should have enough expertise. So that becomes very important for a mediator to help the parties in negotiating the terms and conditions. How to choose a mediator, I think I've gone through all these criteria. Trained, and we have very well trained from international institutions. CAMP has been certified by an international institution, IMI. Similarly, some of us mediators also IMI certified. And experience counts a lot. We all have mediated more than about 700, 800 hours of mediation. In fact, our founder has a huge experience of mediating over about 1,000 cases. And case management, one of the most important aspects. Sorry, I missed this out. I mentioned it initially, but I did not elaborate on it. Case management service, which is extremely important. Case managers are there to guide the parties before the mediation starts. It's extremely important. You don't go in, in an institution, you don't go in straight for you. The process does not start. The case managers are there to initiate the process. They talk to the parties, they explain the process, nothing about the merits of the case, but it is just about the process of mediation, what is necessary for the parties to come forth with vis-a-vis documents, etc. Parties have a lot of questions. How much time is it going to take? How are you going to do it? If it's online, do you have a dedicated platform? Case managers are extremely important to help the mediators managing the whole thing. And we will come out with certain credentials which our mediators have been given. We have, in fact, we have a desk at the consumer forums at Bangalore, and the president of the consumer forum has given us an excellent certification for having rendered mediation services at the consumer forum. Transparency. When at CAMP, another advantage, if there's conflict of interest, we are very clear about declaring conflict. It could be the smallest of conflicts. Most of us mediators are lawyers also. It is possible that we may be, knowing some of the counsels who represent the parties. So to ensure transparency, to ensure that there is no feeling of bias, we declare this conflict so that the parties are free to waive the conflict. And we have very high standards, international standards, of which we follow. Which have been set out. Templates are there at each and every stage for the mediators to follow. Thank you. The next slide, please. Are you taking this, or should I take it, Gayatri?
Well, actually, we don't need to go through this slide, because in telling you how to choose a mediator and what you need to look at, Rukmani used CAMP as an example and model for you to know that these are the parameters that you need to look at while choosing a mediator. And these are the parameters that she discussed with you just now. Let's go to the next slide. But what I would like to just emphasize here is about what is called the CAMP SIMC, that is the Singapore Institute of Mediation, Singapore Mediation Council. Just go to the previous slide, Anubha. Singapore Mediation Council, the CAMP SIMC protocol. Rukmani, I think maybe good if you could do the video. I find that there is a lag here. If you could switch off your video.
Sure.
Yeah, thanks. So this I would like to spend a little bit of time explaining to you about this protocol. This is a very unique protocol put together by the Singapore Mediation Center and CAMP. We put this together at the time of COVID to be able to give access to speedy, fast-track dispute resolution at extremely affordable costs. Wherever there was cross-border mediation in Asia, South Asia, with an Indian party or an Asian party, it actually can even now help you beyond Asia if there are, because we have mediators from Africa or Ethiopia or Middle East on the panel. So if there's a cultural or a context-specific mediator who is required, we bring them on board. This protocol allows for mediators from 2 different countries who are needed for their country-specific knowledge and culture-specific knowledge to come and resolve an international conflict at extremely affordable costs under the umbrella of the Singapore Mediation Center or CAMP Center. Let's go to the next slide. So you have some of these great names. In fact, Sriram Panchu is called the father of Indian mediation, and Laila Olapalli, the founder of CAMP, is called the mother of mediation. We have eminent person like Justice Kurian Joseph and several practicing lawyers and advocates in Supreme Court, but who have chosen to be mediators in order to ensure that access to dispute resolution is speedy, affordable, and can be availed at ease. So you will see that this expertise is available to you along with several other subject matter expertise, which we have on our panel. Next. And the sectoral expertise. It is not just to show CAMP's sectoral expertise, it is also to show to you where mediation can work. If you want to get it in a nutshell, it works in everything which is a civil case or a commercial case, barring a criminal case or cases where a contract was de novo, not contractable, or if someone has come in and entered into with a kind of an unsound mind or does not have the capacity to enter into a contract. So be it workplace contract, partnership contract, all kinds of company matters, intellectual property, debt recovery, whether it's a will or a matrimonial matter or a family business conflict which affects the business as well as the family's own relationships, sexual harassment cases, which in law is considered to be a criminal case or has to go through a certain defined process, is actually mediatable, and the procedures, in fact, recommend mediation as the first step, because many discrimination cases, workplace discrimination, not just sexual harassment, actually are simmering and latent and do not want to be expressed because they do not want to upset anybody else with whom they have to work. So mediation provides a very safe place to discuss and unveil and uncover those processes where productivity or morale is not impacted, and the company can actually become aware of this and address this before they become a raging conflict. Let's go to the next slide. So these are some of the testimonials that I'd like you to see. And what you would see here is Ms. Kamlesh Salera of Mysore Udyog, the owner. He says that we resolved the matter in a day. It was a major dispute with tenants and it was a quick and efficient resolution. And that mediation is far more business-friendly form of dispute resolution. And if you were to look at the other cases where there is actually a Vishwanath Rao, who is a legal partner in a legal firm, talks about mediation solving a pending matter for the last 17 years. And we have a case where one of the managing directors of a family business saying that not only did it help them to grow from strength to strength, but the next generation of feuding families have had a chance to be a family once again. And they were so much impressed with mediation that they said that we will waive confidentiality and we'll come and talk about the benefits of mediation, not just for a transactional resolution, but for preserving relationships in the long term for both strategic as well as human purposes. Let's go to the next. So that's it for now. Thank you very much for giving us a patient hearing, and we are happy to take any questions that you might have.
Thank you, Gayatri ma'am and Rukmani ma'am. There are a few questions that our audience would like answered. One is, how helpful is it to have a mediation clause in a startup contract or in a contract in general?
You're on mute, Gayatri.
Shall I go first and I will...
Yeah, I'll just add in, Gayatri. I'll just add in.
I think mediation is a God-given tool. It's a great tool, especially for startups, which, you know, where the founders are also right from the people who are more or less your own cleaners or janitors of your building to being the owners and CEOs and in holding many avatars. You cannot afford to invest your time and energy in a long drawn litigation or a much more arduous dispute resolution process. So mediation is made for startups. And I would say that the clause should not be seen only for resolving a dispute or a conflict when it arises, but it should be looked at as an early prevention mechanism, that when you have a latent dispute in your minds or unstated conflicts, which might be which would turn unstated differences, which may turn into a dispute. That is also where mediation can come in and stop you from getting into a full-fledged dispute, which affects your productivity and peace of mind. Rukmini?
Yeah, I would just like to add in this, just this bit of it, that having a clause in a contract means that the party is aware of the process, and so they, as Gayatri very rightly pointed out, that before any conflict even starts, parties get used to the process of having dialogues as soon as there is any minor disagreement. This contract helps them psychologically to a great extent of not, that to ensure that communication does not break down and dialoguing continues. Gayatri, mute.
Those of you who are interested, we do have mediation clauses available on our website. Do utilize them, but maybe you will need to modify them with some counsel or some thinking which is contextually relevant. We're also in the process of updating it. So you please visit our website to check, and that's available free to you. And you can look at that and incorporate that in your business contracts or your even founder agreements or investor-investee agreements.
Anything else, Surya?
I can see
another question is, can you elaborate more about mandatory mediation?
Can you repeat that, please?
On mandatory mediation.
Mandatory mediation. I'd just like to take a shot at it, Gayatri. Mandatory mediation. Now, we did emphasize a lot on the fact that mediation is voluntary. So you may find this a slight contradiction, you know, why are we saying it's voluntary and then why are we saying it's that mandatory mediation? Now, when we talked about the bill and we said that the bill was encouraging mandatory mediation, it did not mean that you necessarily compulsorily have to go through the entire process of mediation. It means that there are two mandatorily you try out mediation before you go in for a court process or any other process. This is for the benefit of the parties. Try out the process. What is mandatory is trying out 2 sessions of mediation before you go in for any other process. It is once they come in for those 2 sessions, after those 2 sessions with the mediators, up to the parties to decide whether to continue on in the process or not to continue on the process. So the voluntariness of the process remains. The mandatory part of it is only try out mediation before you go in for litigation. That is what is important, very important to understand. And this over here, I would like to say, while talking about global trends, Italy has has incorporated mandatory, trying out mediation before going in for litigation. And Italy, like India, had a huge pendency of cases because of this mandatory mediation, trying out mediation mandatorily before going in for litigation has reduced their pendency to a great extent.
Okay. I see an interesting question here about what if mediation fails?
Yes.
So Rukmini, do you want to start?
I'll just add in, Gayatri.
Okay. So yeah, mediation can also fail, like a court case can fail and go on appeal, or an arbitration can fail. But we have found in our experience that those are generally much lesser when parties come voluntarily into the process with a commitment to make it work. But even then, let's say a mediation settlement agreement fails, or the process of mediation fails, that is where it is a option, which is a win-win option, in the sense that it does not deprive you as a citizen of this country, governed by laws of this country, to go and explore other mechanisms of redressal or solution that you think you want to adopt. But in our experience, many a time that once a party has tried mediation, and even if it has not concluded into a settlement agreement, the process of mediation has actually enabled them to rethink their hard stated positions and go back and review and make changes. And sometimes they've resolved among themselves and come back and told us that mediation helped us to take this step forward and resolve. And many a time they do come back after reflection, after having tried other means as well. But the good thing is that it is a tool, a very effective tool in the dispute resolution spectrum, which does not deprive you of any other rights that you have to explore conflict resolution.
Thank you.
Yeah, I just want to add in, Surya, I'd just like to add in a word here that I have seen practically, I've seen parties where a couple of times when mediations have not settled, they go back to court, and a couple of months later, say 6 months down the line, because they've understood the process, but for some reason they could not settle. After being in court or in arbitration for say 7 to 8 months, in my experience, I have seen parties coming back into mediation and settling. So that is a great advantage, because they know the mediation doors are not closed for them once they walk out. They are welcome to come back to.
A last question, if any, Surya, and let's wrap up.
Yes, there is a last question. The question is how friendly is CAMP for startups, cost friendly?
I would say very cost friendly. So mediation by itself is super cost friendly, and CAMP would put an icing on the cake if you have any conflicts and you want to explore it with us. And I want to say here that TiE has asked us to explore a mediation desk for all its startup members, and we are actively collaborating with TiE to make that happen. Rukmini?
Yeah, and you know what, at CAMP, rest assured, we have a variety of fees, depending on the experience of the mediators. And moreover, we are not sort of, we change our fee structures also to suit our clients. As we said, it's a flexible process, it's flexible for fees too. That is, rest reassured. That kind of assurance is always there. And mediation fees is shared between the parties. So that much burden comes down on the parties. And we did that comparative study as compared to litigation and arbitration. In all, if you see it as 1/10 of the cost. Thank you, Rukmini.
And thank you all very much for this wonderful evening to present what we see as an extremely important development at a macro level for the country as a whole to reduce the burden of litigation that the courts are reeling under, the access, timely access to justice that the people are reeling under, and at the micro level for individuals to have an extremely affordable and effective mechanism to resolve their conflicts and to move forward into the futures of their desire. Thank you so much. Thank you again, Surya and TiE, for your excellent coordination.
Thank you so much.
Thank you once again.
Thank you, Gayatri. Thank you, Rukmini. This is a wonderful series that we've initiated along with y'all, and I'm sure this is a information that most of us startups can use in their journey, in their entrepreneurial journey. And yes, the ongoing couple of months. I'm looking forward for this, and I'm sure so with our startups. We'll stay in tune with all of y'all. Thank you again so much, and thank you, Surya and Abhinav, for being around. Thank you so much.
Just one thing in passing, we would love to hear your feedback and to also to make it more purposeful for your members. Please do send your feedback and that of your members. We would be extremely grateful for that.
Definitely.
Yeah, thank you.
Thank you so much.